thank you all very much, and thank you, Karen, for inviting me and having me at the Beverly Hills event as well. Yeah, I'm just a country lawyer. University of Chicago Law School, clerked for Clarence Thomas at the Supreme Court, taught constitutional law for 20 years at Chapman University, was a dean for a while. We brought my law school from 168th to 94th in the school rankings in 3 years. It was extraordinary. I used to speak at judicial conferences all over the country as a counterpoint to Erwin Chemerinsky, who always gave them a distorted understanding of the Constitution. And so when I get a call from the White House at the end of November 2020 saying, will you hold for the president? I thought it was a college buddy of mine pulling a joke on me. And Molly Michael convinced me, though it really was the White House and it really was the president calling. And I took the call and he asked me, you know, our cases are not going anywhere. The courts are refusing to look at the merits. They're dismissing them on technicality grounds, 65 of them or more. And would you represent me to try and figure out a way to get these things to the Supreme Court of the United States to get the case heard there? Country little lawyer, law professor, the President of the United States calls you to take on a case in the Supreme Court of the United States. That's a pretty big deal. Many would view that as the capstone of their careers. Of course I said yes. But as the old movie, Sid Caesar movie goes, a funny thing happened on the way to the forum. I gave the president advice based on open issues of constitutional law. Things that have been settled or remain open. Things that have been settled, like Article 2 unambiguously assigns to the state legislatures the sole and plenary authority to direct the manner of choosing presidential electors. That means every time a Secretary of State or a county clerk or a Superior Court judge in one of these swing states violated or ignored or suspended on their own state election laws, that was the manner the legislature had set out. That conduct was not only illegal under state law, it was unconstitutional under federal law. And it invalidated the election. Now, politically, if it was just a minor technicality, you don't want to take advantage of that as a pretext to overturn an election that had otherwise gone to your opponent. So I gave advice to state legislators that said, for political cover, you want to make sure that there's enough of an impact of that illegality to have affected the outcome, because your goal is to still have the certified electors be the ones that reflect the actual will of the lawful voters, not using this as a pretext to put in somebody that didn't have the choice of the people of your state. That was pretty clearly established. What was unambiguous was that. What was ambiguous was what happens if you've got a conflict on January 6th when it comes in between electors who have been certified and electors the legislator is telling you should have been certified but for the illegality? Who resolves that conflict? Well, the one thing we know from our founders and the records of the Federal Convention is they absolutely did not want to have Congress having any role in the choosing of the president. That makes us a parliamentary system where the president is subservient to the legislature, rather than a separation of powers system that they'd spent the whole hot summer in Philadelphia trying to design. So if it's not Congress, who is it? Well, you could send it back to the states, or you could have the vice president serving as the president of the Senate, who under the 12th Amendment has the sole authority to open the ballots. The Congress's role, explicitly defined there, is to be present. The vice president, the president of the Senate shall, in the presence of the House and Senate, open the ballots, and then they shall be counted. So the shift to the passive voice, and they shall be counted, creates a bit of an ambiguity. But the House and the Senate are only there to be present. The only affirmative role is for the president of the Senate. That's the vice president. He's the one that opens them. Implicitly, therefore, if I've got two sets of envelopes, I got to decide which ones are the valid ones to open. And then they shall be counted. So there's some ambiguity there, but the scholarship at the time, most people running away from their own scholarship, the scholarship at the time was decidedly in favor of the only person that had the authority here is the vice president. And so that was the advice I gave. Not to just simply reject Biden electors, although Mark Short, the chief of staff for the vice president, leaked that story to the New York Times the week after. Because what the vice president did on the morning of January 6th, knowing that my advice had been to simply accede to requests from hundreds of state legislators in these swing states, who told him our election was conducted illegally, in blatant violation of the manner we, the legislature, had set out. Our governors have refused to call us into special session to deal with this problem. We're now back in regular session, and we would like a week or 10 days to try and sort this out and tell you, were the Biden electors legally certified, or can we marshal enough evidence of illegality and the fraud that flowed from it to determine that, in fact, the choice of the people of this state was otherwise? Give us a week or 10 days. Delay. That sounds pretty reasonable. And we've got historical precedent. There's language in the 12th Amendment that says if nobody gets a majority, it has to go immediately to the House for resolution of a contingent election in the House. The word immediately doesn't exist in the counting of electoral votes itself, which in 1876 the Congress itself used to say, well, we didn't have to immediate, we can set up a commission to try and sort this dispute out. So based on that historical precedent and that language of the Constitution and that unsettled open issue, I gave the advice to delay. That sounded reasonable. In the letter to his dear colleague letter in the morning of January 6th, the vice president, knowing he was going to be breaking with the president, was trying to put the best face on it he could. And that reasonable advice wouldn't go down well for his future political career. So he had to make it look as if we'd asked for the most aggressive thing, which was to just simply reject the Biden votes, accept the Trump votes, gavel Trump reelected, and he said, I don't think our founders would have ever liked that. Mark Short leaked to the New York Times that I was the one that did that, which is blatantly false. Under oath, they've now acknowledged that in that meeting in the Oval Office on January 4th, my advice was not to do that. I said it was an open question, as it was, but I think it's the weaker argument, which I think it is, particularly in those circumstances where the alternate electors were not certified by anybody. And I think if you were to do that, it would be foolish. Those were the exact words I used. But I do think you should accede to these requests to delay, to let the state legislators that have the authority here let you know what their actual determination is. That came out 10 months later in the New York Times article attacking me, but they got this one right. They quoted somebody familiar with the meeting. And so it was either the president, I don't think he did it, the vice president, I don't think he did it. Mark Short, he had lied previously, so I don't think he did it, and I know I didn't do it. So that meant it was Greg Jacob that told the New York Times the actual story. Well, no, Eastman didn't actually give that advice at the Oval Office meeting. It was rather to delay. And then he testified under oath to that effect before the J6 committee as well. So this whole narrative was crafted around a false story, and it has now been used to launch out after me for giving what I thought was fairly serious, supported scholarly and historical precedent, as well as textual commitment. And I gave that advice. So for the effort, I have been named as unindicted co-conspirator number 2 in D.C. and Jack Smith by a special prosecutor who has no constitutional authority to have been appointed. I've been named indicted co-conspirator number 3 in Georgia by a, let me put this delicately, ethically challenged DA in Fulton County, who's bringing charges of violating state law for actions taken in exclusive arenas of the federal courts. We may win on that issue before the trial judge, because he asked a couple months ago for supplemental briefing on the Supreme Court's decision in a case called Loney, which says, it dealt with electors, and somebody said an elector had falsely notarized their papers. And he said, well, falsifying a notary normally is state law, but when the purpose of the notarized paper is for an exclusive federal issue, the state courts don't have any jurisdiction. I thought that might have some relevance to what's going on in Georgia. And then a couple of months ago, I was named as indicted co-conspirator number 13. I'm kind of going down the list. In Arizona, And I can't figure out why. I mean, I had no communications with electors in Arizona. I had no involvement in the litigation in Arizona. I responded to a request from a state legislator to talk to their speaker, who said, we can't call ourselves into session. And I said, well, actually, when you're exercising powers under the federal Constitution, you can. That was it. That was the sole role. But I think because I speak out so publicly about this issue, they wanted to put me into the mix. I don't know, for PR value or what. But, you know, an interesting little thing happened here, and I'll talk about California Bar in a minute, but an interesting little thing happened in Arizona about almost 2 years ago now. This gets into the weeds a little bit, but there's a thing called a SLAPP suit. It originated with largely developers who wanted to build a lot of housing in your neighborhood, and people would show up at the planning commission and complain about it. And then they would sue the people that showed up at the planning commission for defamation, to send a message nobody else ought to dare oppose our project in future planning commission hearings. Strategic litigation against public participation, SLAPP. And the state's gotten involved in this and saying you're infringing on their freedom of speech and their right to petition the government. And so we're going to create a statute that allows them to anti-SLAPP you, to bring a motion to get rid of your case, trying to prevent them from testifying, to get rid of it on the front end, unless you can prove, before you get any discovery or anything else, prove that they actually violated your defamation rights. And if you can't do that on the front end, the case gets dismissed, and you have to pick up their attorney's fees. So anti-SLAPP. Well, Arizona, a little under 2 years ago, added criminal prosecutions to their anti-SLAPP statute. First state in the country to do that. So I told my lawyer down there, I think we're going to file an anti-SLAPP motion. And she does the research, and she says, there's no case law on this. I said, I know, because it was just passed 18 months ago. We're going to be the case law. And she said, oh, I don't know. And I said, well, I'll tell you what. It's about First Amendment issues. I'm kind of one of the experts on that issue in the country. Why don't you let me write a draft, and then you can decide. So we filed an anti-SLAPP motion last Friday. And if I do say so myself, I think it's pretty good. In Arizona, you got to prove two things. One, that the case involved the exercise of First Amendment rights to speech, to the right to petition the government for redress of grievances, and we laid out all the case law saying when I speak on Steve Bannon's show, that's protected speech. When I speak at the mall in front of the White House on January 6th about illegality we saw in the election, that's protected speech. When I ask the vice president to try and do something about it in his official capacity as president of the Senate, that's the right to petition the government for redress of grievances. When I testify before the Georgia legislature, telling them that if in fact the laws were broken and you determined that it had an impact on the result of the election, you have authority to do something about it, that's petitioning the government for redress of grievances. In fact, it's not at the edge of that constitutional right, it is at the core of that constitutional right. One of the charges against me in Georgia was that by testifying at their request, they called me as an expert to testify, that I was soliciting the legislature to violate their oath of office. That's the one charge that was dismissed against me. By the way, there are 9, so I still got 8 others that I got to deal with. I'll tell you how you can help on that, and all the people that will be watching this as well can help on that. But it's classic petitioning the right of the government for redress of grievances, and grievances we had aplenty. The other thing you've got to prove in your anti-SLAPP motion in Arizona is that the prosecution was designed to retaliate it against you or deter you from the exercise of those rights. And you got to make out a prima facie or on its face or at first blush argument of why that happened. Well, you know, the current Attorney General in Arizona who brought these charges helped a lot on that. In her campaign, she said, we got to stop these election deniers, and I'm going to prosecute them. I mean, it's just, I just quoted her own words back at her. So we'll see that was filed last Friday. We'll see what happens on it. Different matter in California, and this is where I want to pick up on something Frank Gaffney said. This is not a shooting war like we're used to, but they are using our institutions. And one of the institutions that I'm most familiar with is this use of the criminal courts, the civilian courts, the defamation cases, and the disciplinary procedures to go after their political opponents, lawfare. There are several groups doing this around the country. The one that filed the complaint against me in California is a group called States United Democracy Center. One of the witnesses called in the bar trial against me used to work at States United Democracy Center, and she's now the Deputy Secretary of State in Arizona, so she was called as a witness about how the election in Arizona was perfect, and therefore when I was raising questions about it, I must be lying. And they're going after me for moral turpitude and lying because I said things different than what the government said. We're the government, and what we say is true, no matter how blatantly false it is. And if you don't accept it, repeat the untruth, and come to believe the untruth, this is starting to sound like Orwell, then you must be lying, and we're going to charge you with moral turpitude. That was the phrase they used repeatedly in my California bar. My favorite one of those, and I'll get back to her in a minute. Well, no, we tried to challenge her bias for having been an employee of the organization that filed the complaint against me, and the judge wouldn't let us ask those questions, and it was not relevant. One of the many issues we're taking up on appeal. One of the charges against me was on January 6th, I said that dead people voted. And the paragraph charge in the California bar complaint said, he said dead people voted. He knew that was false, and therefore an act of moral turpitude, because by then the Michigan Inspector General had already determined that only 1,500 dead people voted in Michigan. And I said, you've just proved that my statement was true. And their argument was, well, yeah, but what you really meant by that was more dead people voted than would have affected the outcome of the election. I said, I never said that. This was but one example of the many things that went wrong. And you've admitted that what I said was true. And so I said, so in a footnote in our opening brief, we said, they should be prosecuting themselves for filing a false statement in the court that what I said was false, when in fact they admitted that it was true. But nothing, of course, came on that. Why is this so pernicious? The head of the 65 Project, one of these other outfits that got a lot of money from Soros-front organizations to bring these disciplinary proceedings, they brought him against more than 100 lawyers. And for whatever reason, I became the poster child of this effort. The head of one of the founders of it, David Brock, in a very important interview with Axios magazine, asked him about this, and he said, our goal is not just to have all these lawyers disbarred, but to make them so toxic in their firms and their communities that no lawyer will want to step up and take on these kind of cases again. In other words, they're designed to try and scare people out of fear into silence and submission so that they have a free hand to do whatever they want with the next round of elections with nobody willing to stand up and fight them. That's where we are. And the question is, do we have enough courage to stand up against it? And I'm going to tell you two stories where I draw optimism. One of my clients, a little 12-year-old boy in Colorado Springs, Colorado, named Jaden Rodriguez. You may not know his name, but his story went viral, so when I tell you the story, you'll know immediately. He's the kid that got suspended from school because he had a Gadsden flag patch on his backpack. And that kid said, I'm not backing down. His teacher told him he couldn't wear it. The vice principal told him he couldn't wear that patch on his backpack because it was a symbol of slavery. And he stood up and said, no, ma'am, it's a symbol of fighting against tyranny. He knew more than his teachers did, or than his teachers feigned to know. And he stood his ground. And then when they suspended him, his mother reached out and contacted me because, thank you, Liz Cheney, I've become, I think, one of the most famous lawyers in the country. And I took on their case. It's a wonderful case. But the kid had courage. And the students surrounding him have courage. They've made little stickers of the Gadsden flag patch, and they keep posting them on the lockers in the schoolroom. And that every night the custodian crew is ordered to rip them all off, and they just keep doing it. Courage is contagious. I'll tell you another story. So the Claremont Institute, is this water? Can I have that? the Claremont Institute, where I'm a senior fellow and member of the board, they do a series of fellowship programs every summer. The Publius Fellowship Program is the longest standing one. You may recognize some of the names of people. Oh, thank you. Laura Ingram, Mark Levin, we got a bunch. What's that? Nash D'Souza, John Eastman, teaching them about the principles of the American founding, thing they should have learned in high school civics or at least college government classes and never did. And then we have the Lincoln Fellows Program for mid-career chiefs of staff or legislators, that sort of thing. And then we have the John Marshall Fellowship Program that I run for recent law school grads. And so last summer's class was coming to study with me and some others in the middle of all that's going on. I'd not yet been indicted in Georgia when they were offered admission to the program. But they created a listserv. I was already the target of the hearings in the J6 committee, and they created a listserv among themselves, wondering how much damage it would cause to their long-term career prospects to having studied with me on their resume. And they, to the one, decided, we've got to take a stand here, and they all came. And then during the week that we were there was when the Georgia indictment got handed down. And so at the end of the week, we always throw a nice dinner and good wine, and they roast each other, and occasionally they'll give a little toast to thank the faculty. But this was just, you know, the 800-pound gorilla in the room. They had to talk about it, and so they decided to roast me, not just toast me a little bit. I said, Eastman was teaching a seminar on the religion clauses with Notre Dame professor Phil Munoz and former California Supreme Court judge and D.C. Circuit Judge Janet Rogers Brown on the religion clauses. And the indictment came down, and all of our phones started buzzing, you know, and all this. And they said, Eastman's teaching about the religion clauses. And jackbooted thugs from the FBI start rappelling down from the rooftops and come in and arrest him, and they're carrying him out, and he's still teaching about the religion clauses. Now, obviously, that didn't happen. But they said that what I manifest by continuing to stay focused on what we were teaching for the long-term viability of our republic, that I exhibited some courage there, that they drew sustenance from and rededicated themselves to it. And then the guy closed with this. He said, you know, if you think about the closing lines of our national anthem, the question they ask, is the flag still flying, is less a question about whether the flag still flies and more a question about what kind of land the flag is flying over. Is it still the land of the free and the home of the brave? Or has it become the land of the coward and the home of the slave? And everyone in the room teared up, as I did, as I am now. And they said, we are so appreciative of the lessons that you are teaching us in this class, but more importantly, the lessons that you are teaching us by your willingness to stand up and fight against this tyranny, that we have decided to dedicate ourselves to being in this fight, to staying in this fight, and ultimately into winning this fight. And that's what it's going to take for all of us. Thank you.